rise. The Court of Appeals, Division 1 is now in session.
Good morning, please be seated. I hope the bailiffs changed the water cups because okay, good. I'd be nervous if Judge Weinsweg had to drink after me. Hello today, everyone. We're here today for oral argument in the case of Mast et al. V. Mays et al. Our case number 1 CV24-0442. As you guys know, this matter is being live streamed and recorded for YouTube and posterity. So when you get up and announce yourself, make sure you announce yourself and the parties whom you represent so that the dozens of viewers that we'll get over the next decade can keep track of everything. We have conferenced this matter. We are familiar with the briefs and with the record, so keep that in mind while you're making your presentation. I think each side gets 25 minutes. Is that correct?
Yes, Your Honor.
All right. And I think appellees are dividing time among how many people? Just 2? That's all up to you all. I don't enforce it, so if you, whoever goes first eats up the other time, you have to yell at them, not at me. If either of you want to reserve time, or if appellees, if appellant wants to reserve time for rebuttal, that's also up to you. I'm not going to cut you off. You want to keep talking, you keep talking.
Thank you.
Anything I've missed? I think I covered it all. All right, with that, we will begin.
And to begin with, Your Honor, I'd like to reserve 7 minutes here. Okay. So, may it please the court. My name is Ryan Heath. I represent Mr. Abe Hamadeh, David Mast, and Tom Crosby in this matter, who are the appellants. I think the weight of this decision needs to really be understood by the court. If the appellees have their way, then any election official can cover up misconduct past a 5-day statutory period of repose, which is the election contest statute, and they can get away with it. No matter if it's intentional, no matter if it's negligent, that's the position they are arguing for. Throughout this case, the appellees and their counsel have attacked myself personally, my clients personally, claiming this case is bogus, that it was frivolous, that it was not brought in good faith, and nothing could be further from the truth. The cases that have been cited by the opposing parties here do not relate specifically to the circumstances at hand. Rather than focusing on the issues of the merits of this case, most of the time here spent has been on attacking, again, myself and my clients.
Counsel, let me ask you, did Maricopa County in May of 2022 release a 2022 election plan?
Yes, Your Honor, of course.
And did that election plan say that Maricopa County intended to apply for verification of early ballot signatures, stating that, quote, historical reference signature, it would be compared to a, quote, historical reference signature that was previously verified and determined to be a good signature for the voter? Did it say that?
It did, Your Honor, and It also said a few other things that I think
right.
important.
Well, and we can get to those, but it did say that.
Yes, Your Honor.
And that's what you're here today to challenge, right?
Yes, Your Honor, the ambiguity of that particular phrase.
So why should we listen to your argument now when you had 6 months before the November election to bring this identical challenge?
Well, that's a great question, Your Honor. And the reason that we waited until after, September, August is when we filed in the Supreme Court, was because the language used in the election plan was not specific enough to give the public notice of what it was that Maricopa County was going to be doing. And
you have the language in front of you?
Your Honor, I can paraphrase. I don't have it right in front of me. I know it's in the briefs.
All right, so give me exactly the reason why this wasn't sufficient to put you on notice to challenge.
Yes, Your Honor. So the phrase in question is early ballot affidavits, and that's directly from the elections plan. Early ballot affidavits can mean a number of things. Presumably, as we were entitled to believe, based on the clear and convincing standard here, that public officials actually abide by the law absent clear and convincing evidence to the contrary. That phrase, the ambiguity of that phrase, meant that they would only be comparing to these reference signatures to the signatures that are from early in-person affidavits. And that's because the EPM specifically...
Wait, you added words there. Why is in-person?
Yes, Your Honor. There is a distinction here the court really needs to understand. There's a difference between an early vote-by-mail affidavit and an early in-person affidavit. Both of these documents have to be signed. You have to sign an affidavit envelope whether you vote in person early or whether you vote by mail early. And that's important because when you show up to an early voting center and you sign an early in-person affidavit...
But they didn't use either of those phrases in the May 2022, is that right? Yeah.
Correct.
Thing. So why are you saying that now in-person should be considered?
Well,
It seems like there's at least a pretty severe ambiguity that you should have been on notice for and challenged at the time and said, look, just in case they're trying to construe it this way, we want to stop that.
Well, I think it's important to look at the other provisions of law here that were in question. So the 2019 Election Procedures Manual, which was in effect at the time, that manual actually specified which documents were included in the registration record. It said that early PEVL request forms, that's permanent early voting list request forms. It also said that the signature rosters, where you also show an ID, you have to show an ID to sign either of those documents. And finally, it specified on page 98 or 99 of the actual EPM that in-person early affidavit signatures could be included in the registration record. It did not say anything.
Yeah, but the 29 was superseded by the 2022, or the 2019 was superseded by the 2022. So.
No, Your Honor, there was in 2022, the 2019 EPM was actually in effect. There was no 2022 EPM in effect.
I understand you're on the sanctions part. You know, the point is that you're challenging almost two separate documents, the 2019 and the 2022. That's what you're saying, right?
Well, I'm saying the election plan that Maricopa County published was consistent. It was theoretically consistent with the 2019 EPM insofar as the ambiguous phrase early voting affidavits was referring to in-person affidavit envelopes, which is actually explicitly allowed to be in the registration record by the 2019 Election Procedures Manual. Now, this is actually consistent with Arizona law. If you look at ARS section 16152, this is the registration procedure under Arizona law. That says that you actually have to provide certain identifying information when you register to vote in Arizona. That includes evidence of United States citizenship. Now, why is this important? It's important because the Constitution of Arizona provides explicit guarantees to Arizona voters. This is unlike any other constitution in the United States, to my knowledge. It says in Article 7, Section 2, that you have to be a citizen of the United States to vote in our elections. It also says that there shall be enacted registration and other laws to secure the purity of our elections. It also indicates that only the person who receives the highest number of legal votes shall be declared elected. Those are fundamental rights that are conferred to us by our founding fathers. And what's important about that is that these laws, ARS 16550A, which is the statute in question here, back in 2022 when this election occurred, it said that on receipt of the early ballot or early ballot affidavit, the county recorder shall compare the signature thereon to the signature on the voter's registration record.
So what document is this you're talking about?
This is ARS section 16550A.
Okay, the statute.
Correct.
Registration record, not defined.
It's not defined, but the clear...
But how do you get over that May 2022 document, which you say is ambiguous? I'm not so sure about that. How isn't that just destroy your entire case, or at least the non-mandamus part?
Well, again, this has to do with whether or not the public was sufficiently put on notice by the language from Maricopa County's election plan.
Right, so let's talk about that. Mm-hmm. Okay, so let me read it to you.
Go ahead.
The early ballot signatures would be compared to a, quote, historical reference signature that was previously verified and determined to be a good signature for the voter, including early voting affidavits from previous elections. That's a quote. Mm-hmm. How is that ambiguous, such that you had no knowledge from which to come to this court as people do, which is in advance, but that you want to cut line after.
Yes, Your Honor.
Before you respond, I'm hearing some murmuring from the crowd. Don't talk if you're behind the bar.
There are two different types of early affidavit envelopes in Arizona. One is an in-person early affidavit envelope. The second is a vote-by-mail affidavit envelope. The in-person one is white. The mail affidavit is green. And when you go to vote in person, this is what the EPM states. It's on page 98 or 99. You have to show your identification in accordance with Arizona law, which means that you are registering to vote in that act. When you sign an e-poll book, for example, as well, you have to show your ID before you sign that document.
I'm just asking you to talk about these words, okay? Not this or not that. We have a document in May of 2022 that seems to put you on notice. I'm asking you why, what are the words here that threw you off? I mean, we have, quote, early voting affidavits from previous elections. Is that some different signature that I'm thinking of, or is that unclear that whether that's what they exactly did? Again, this is what troubles me, and this is what I want to get a good sense of, is why that did not put you on notice. Those words.
Those words did not put us on notice, Your Honor, because they are ambiguous. Under Arizona law.
Can I ask a clarification question on that ambiguity point? Is your ambiguity determination driven by, it seems like you're tying it back to the 2019 EPM. Are you saying this 2022 document was ambiguous because there was a sort of overriding statewide election procedures manual that defined this, and so you were reading that within the context of the election procedures manual? Is that?
That's exactly right, Your Honor.
What makes it ambiguous? That
is exactly right. And that's because.
So explain that.
Yeah, that's because the EPM explicitly includes these in-person early affidavit envelopes, the ones you sign when you show your ID, in the registration record category. It does not even mention early vote-by-mail affidavit envelopes. It doesn't say anything about them, and it also includes PEVL request forms where you show your ID. It also includes signature rosters and e-poll books where you show your ID. It does not include early vote-by-mail affidavit envelopes, and that we believed, based on the early affidavit envelopes that was being referenced in the 2022 document, they were referring specifically to the in-person affidavit envelopes, which is what all other counties across the state of Arizona are actually doing right now. Maricopa County is the only county in the state that actually allows its signature reviewers to sit down in front of their screens, and on one side of the screen they see the signature from the voter who's trying to cast a ballot. This is from their affidavit envelope. And on the other side of the screen, the only other thing that person sees is the most recent historical signature submitted by that voter. To see anything else, that reviewer needs to physically scroll down. Now, what happened in the 2022 general election, and this is really irrefutable, Maricopa County approved hundreds of thousands of signatures and actually tabulated those votes within a matter of seconds. There was no time for the reviewers to scroll down and actually access anything other than the most recent historical signature submitted by that voter. So,
as a legal matter, if there is anything that guides this question, what is the relationship between Maricopa County's election plan and the election procedures manual?
The election procedures manual sets the minimum bar for what must be done by the counties across the state with respect to signature verification. And what Maricopa County did is they surreptitiously changed the definition of the term registration record with their historical record.
Surreptitiously is a loaded phrase. How did they surreptitiously do this?
That's a great question, Your Honor. So back in May of 2022, when the election plan was published, Maricopa County on its website actually publicized, and this is in the complaint as well for both complaints, actually just the first one, but it's in the record. They publicized that the only document that signature reviewers would look at was the original registration form submitted by the voter. Once they changed their policy, they actually expanded the scope without telling us what they were going to be doing. They didn't tell us about whether the reviewer in front of the screen was going to have just one signature and have to scroll. There's not a single public record that actually explains how the process works. They didn't tell us which documents in particular were going to be listed. They gave some examples. But what Arizona law requires, if you are registering to vote in Arizona, you have to be a citizen. You have to provide evidence of United States citizenship. Absent that, ARS 16166 says the recorder shall reject the application. So I think Judge Napper put it pretty brilliantly in his opinion on a similar issue when he said that registering your child to play in a soccer tournament is not the same thing as playing in a tournament. Registering to attend law school is not the same thing as attending classes. Registering to vote is not the same thing as voting.
Didn't Appia rule against you eventually?
So Judge Napper actually changed his opinion after the 2023 EPM
So
came
he
out.
did.
But it was actually interpreting a different law. It was interpreting ARS 550.1, which was a new provision that had been adopted by the legislature.
And it's in effect today.
It is in effect today, but his opinion as far as the 2019 EPM and his understanding of what the registration record meant still applies to the original ARS 16550A, which was in effect at the time of the 2022 general election.
Right, and don't get me wrong. I'm not saying registration record is like Apple for the letter A.
Mm-hmm.
Okay, what I'm saying is you had notice of what they believed to be sufficient. And you concede that. You just say it wasn't as clear given this 2019 backdrop.
Yes, Your Honor. And the 2019 backdrop in particular still requires a reference to a registration record signature that's very clearly in ARS 16550A. And so the question for this court must be, what does that term mean? What is a registration record? And Arizona law specifically requires a person to provide evidence of U.S. citizenship and identifying information that is enumerated by Arizona statutes in order to register to vote. If this court is to read registration record as historical record, then the word registration would be superfluous, which would be just unacceptable. I think.
Well, the good news is we wouldn't even have to reach that if this was a challenge you had notice of 6 months before the election.
If it were a challenge we had notice of, Your Honor, but our position still is that we did not have notice.
Let's say I agree with you that there's at least some slight ambiguity in the 2022 language. I'm not sure I do, but let's say I do. Why weren't you required to challenge that ambiguity ahead of time?
Well, Your Honor, if we
What's
had...
your best support for saying you can sit there and say, I'm not sure what they're saying here. I'm going to wait and see how it plays out.
Well, if we had filed the lawsuit ahead of the election and we had assumed that Maricopa County was using these vote-by-mail affidavits and made those allegations in the complaint.
Which is certainly consistent. I mean, they use very broad language, all
Right.
prior,
If we had,
including early ballots, and they don't say in person. So
we would have been fighting against the presumption that elected officials are presumed to actually act in accordance with law, absent clear and convincing evidence to the contrary. It would have been an almost impossible hurdle to overcome at the motion to dismiss stage.
they would have had to have said, what?
Well, they would
Yes,
have.
we're going to only use the in-person ones, and then you wouldn't be here today.
They could have done that, Your Honor, but they didn't. And you know what?
Because you didn't sue ahead of time to clarify, which is what the law in our Supreme Court has told us you have to do. If you've got an issue with the election procedures, you've got to raise it ahead of time as long as you have notice. And I don't see how you can look at this and their broad language taking out in person from 2019 and saying that we didn't have any idea they were going to not require verification versus in person.
I think it's important to consider what every other county in the state is doing. Maricopa County is the only county here in Arizona that is actually allowing its signature reviewers to engage in this exclusive comparison process.
And I find it troubling, but we're told you have to bring these challenges ahead of time.
I understand that, Your Honor, but I believe that there is some leniency here as far, at the very least, with respect to the issue of sanctions. This is a good faith argument.
Go to sanctions in the Republican Party case.
Yeah, so that case in particular, and this actually is another issue that we filed in a related case. So one of the requests for judicial notice taken below was with respect to another case that I filed on behalf of Abe Hamadeh. There was a decision issued earlier this month, just actually a week and a half ago, where on very similar claims, the court found that sanctions were inappropriate. The constitutional claims were found to be novel. It may have been a long shot, but this type of lawsuit, even brought after the election, is something that had never been tried before. No one in Arizona history has ever filed a lawsuit like this before. And we shouldn't be punished as plaintiffs and as attorneys in particular for trying something new when it is supported by law. And that's what the Republican Party v. Richer case says. I know I'm into my 7 minutes here, but I do want to go ahead and reserve that time. I will walk the court through some of the implications when I get back up. Thank you.
Good morning. May it please the court. I'm Eric Spencer with Snell & Wilmer, LLP. I represent the Maricopa County defendants. I think this case is far less complicated than the appellant's presentation just made it, and frankly, the claims were so clearly barred that they were sanctioned here. On these points, I'll take the laboring oar on behalf of all of the appellees today, using about 2/3 of our collective time, and my co-counsel, Ms. Carlson with the AG's office, will use the other 1/3 to focus on the quo warranto issues, which are particularly within the expertise of the AG's office.
So, Mr. Spencer, could I ask you just to start at that point that I was getting at? Help me understand on behalf of the county, what is the county's prerogative to depart from the election procedures manual in the election plan? How do those documents work together? And you have some unique expertise as to both of those documents. So maybe you could help me understand better whether the county has the leeway to authorize procedures that are below that floor threshold, as your colleague suggested, as is found in the EPM.
Certainly. Well, no county has the ability to implement a procedure that conflicts with the EPM, but it may freely supplement areas where the EPM has not expressly regulated. And in this case, the EPM on page 68 clearly authorizes the registration record to include documents beyond just the literal registration forms, and it provides the authority to include other official election documents in that record.
Does the EPM limit those to in-person verified documents?
Not at all. There's no language in the EPM that limits that. There is a brief 2-item list that says such as, which is illustrative, but that constitutes a floor, not a ceiling.
So one reading the EPM would have only in terms of language and examples, would have a more restrictive pool of documents, but your point is it doesn't explicitly restrict it, so Maricopa County was free to go beyond that.
That's right. Just as Judge Pineda recognized in her order below, the EPM says the recorder should, quote, also consult additional known signatures from other official election documents in the voter's registration record. It's, an early ballot affidavit.
The registration record at that point was defined more narrowly, wasn't it?
No, I disagree, Your Honor. When the legislature changed ARS 16550A from registration form to registration record, it more clearly authorized additional documents beyond just that original voter registration form to be included. And in fact,
used an LY word there clearly, so every time I hear that, I just feel reminded of Professor Lowe saying, when someone says it's clear, it's not. So
okay.
Tell me exactly what language they changed that you think makes it clear that we're allowed to, or that you were allowed to expand this.
Well, in 2019, ARS 16550A was amended in various ways, one of which was to take out the word form and include the word record. Record symbolizes and is synonymous with the voter registration database. And in the voter registration database, you have signatures from various sources, including the registration form, but also from signing in a polling place, and most
it's
prolific.
Still tied to registration, and so, but you guys are using stuff that was done in balloting, right?
I disagree. It's tied to. It's not exclusively.
Changing from registration form to registration record seems to be at least arguable that you're not talking about an early ballot signature. You're talking about stuff that they might have filled in registering to vote.
It's arguable, but not correct.
Okay.
Registration record is synonymous with voter registration database, and I would point out a recent amendment.
And your authority for saying it's synonymous is?
A recent amendment by the legislature this year created a new statute, ARS 16550.01, and in subsection H of that statute, it codified the Secretary of State's 2020 signature verification guide as the Bible for verifying signatures. And that 2020 signature verification guide, which is now retroactively the law, used registration database synonymously with registration record over 20 times in that document. So I think that's an after-the-fact recognition by the legislature that going back to 2020, database was synonymous with record. But I want to be clear, to decide this case, we don't have to, I think as you recognize, we don't have to interpret 16550A and what registration record means, because the challenge was too late and they don't have a proper mandamus claim. And I can go into that more. On the challenge too late, I think the appellants clearly recognize that that's the rule. They just don't believe that they're subject to it. They seem to hang their hat on an alleged ambiguity in the 2022 election plan, but I want to be clear, there's no necessity for a county to even create that plan or publish that plan.
On the timeliness question, I want to ask you about, so for it to be too late, this had to be a pre-election procedure. What makes something a pre-election procedure? Because this is a procedure that did not occur until after balloting, right? So like the procedure of checking the signature couldn't occur until somebody has cast their ballot.
I disagree, Your Honor. If the county had announced procedure A, but then proceeded to verify signatures according to procedure B, then we'd be in election contest territory, and that would not necessarily be a pre-election challenge. But here, we published procedure A, and we used procedure A. That's a procedural challenge that falls right within Tilson.
Okay, I guess I was trying to get out, how do you so what you're saying is that the definition of a pre-election procedure is not driven by when the procedure occurs. In other words, the verification itself, that timing has nothing to do with what pre-election versus post-election is.
I would agree with that. The procedure is the structural way that a county runs an election. It's the same as announcing.
So like my sort of simplistic, basic English kind of looking at it, pre-election procedure means procedures that occur pre-election.
I would say
you're saying that's a wrong definition.
I think the better, not wrong, but I would say the better definition is a procedure for how the election will be conducted that is known or knowable ahead of the election.
So the defining characteristic is the time at which it is known.
Yes, that is a significant element, but I think the real dichotomy is a procedure is the way that a county intends to carry out an election, and an execution issue, which is more of an election contest issue, is how they actually did it in practice that was not knowable. For example, if the county announced that it was going to have 100 polling places and a litigant is upset about that quantity, that's an announced procedure, even though voting hasn't begun, even though we don't know how many of the 100 are going to open. That's something that's knowable and must be challenged in advance of the election. But if on election day the county closes a couple polling places, that's a deviation from their announced procedure. That's something only knowable on election day, and that has to be done through the contest statute and need not be filed pre-election. That's sort of the dichotomy.
So let's talk about quo warranto. What's your best argument that it also needs to qualify as an election contest under 16673A?
May I give a half answer and
is it fairly debatable?
Is what fairly debatable, Your Honor?
Is it fairly debatable whether a quo warranto action qualifies as an election contest under section 16673A?
Ms. Carlson is going to address that, but I would say no, the quo warranto statute can be complied with, notwithstanding the contest statute. The Res v. Jennings case took place after the expiration of the election contest period, but for other reasons, the quo warranto statute doesn't apply here.
Sounds like Judge Weinsweg was alluding to a sanctions issue. Let me ask you just like a generic, broad question, and I might ask the same question to your colleague. If a plaintiff brings a case outside the statute of limitations, but has some arguments on why it wouldn't apply, we would never apply, or courts would never sanction a plaintiff for just bringing a case outside the statute of limitations, would they?
If that were the conduct alone, that would be difficult to sanction, especially because the discovery rule applies to a statute of limitations. The election contest.
Arguing the same thing. We didn't discover. We thought that we assumed you were being consistent with 2019 and with what every other county. We didn't realize until afterwards that you weren't.
I'd answer that in three ways. Number one, I know of no exception to the Tilson-Kirby rule that says that you can avoid a pre-election challenge if you don't find out about the alleged impropriety until after the election. Number one. Number two, the contest statute, which would be their fallback here, that they didn't exercise. Well, Mr. Hamadeh exercised it twice, but he decided not to exercise it for a third time. That's a statute of repose, not a statute of limitations, and no matter what evidence is later discovered, you cannot bring a late-filed election contest. And number three, Your Honor, the fact that they claim that they discovered something late is a contrivance. They hinge this on testimony that one of the election directors gave in the Lake v. Hobbs trial in May of 2023. That is a pretextual hook that they're using to get into court, but it's just not credible. So to answer your question.
To the discovery rule, though, I mean, it does seem like, at least in my review of the record, that there was a genuine surprise that these records weren't being reviewed consistently with how they had been in the past. Is that not fair?
No, I don't think it's fair, Your Honor. The Lake v. Hobbs case was a timely filed election contest, and in that lawsuit, they discovered this information. So it's possible to comply with timelines and discover things that you didn't perfectly know before you filed the lawsuit. But, you know, Mr. Hamadeh in this case filed 2 prior contests and alleged that ARS 16550A was not being complied with, that the registration record contained items that shouldn't contain, and that Maricopa County was verifying signatures against records that weren't authorized to be in the record. So that was enough to file a contest. Now, it should have been filed even before the election. But that's the reserve parachute here that they didn't exercise, and that's also why they can't use mandamus this late in the game.
Did the Superior Court set forth any reasons why it sanctioned your voter clients? The voter clients, Mast, Mast and Crosby?
My recollection is that the order did not, it did not distinguish, let me say it this way. Part of the imposition of sanctions hinged on the repeated lawsuits that Mr. Hamadeh filed, so obviously that doesn't apply to Mast and Crosby. But I think the groundlessness and the lack of good faith did apply to Mast and Crosby.
But does she specifically, did the Superior Court judge specifically say that? Here are the voters, these are the things that are leading me to sanctions, here's the sanction.
I don't think she was that granular when it came to Mast and Crosby. Unless there are any other questions, I'm going to defer to Ms. Carlson.
Thank you, counsel.
Thank you.
Good morning, Your Honors. I'm Kara Carlson. I represent what I'll call state defendants, so the Secretary of State and the Attorney General. And I would like to address the quo warranto issue. Mr. Hamadeh did not seek leave, nor was he granted leave to file this lawsuit, which is required under the quo warranto statutes. And he cannot plead the strength of his own title for a few reasons. But let's begin with what quo warranto relief is. It's an extraordinary remedy, and I mean, I think that if we just think about what it is doing, it's pretty obvious why it's extraordinary and why it is restricted by the legislature. It allows the court to remove a person who has been elected or otherwise appointed from office, and the doctrine of separation of powers, which is explicit in our state constitution as opposed to the federal constitution, obviously makes that exercise something that the courts need to be respectful of. And so that is why the state statute ARS 12-2041 allows an action to be a quo warranto action only to be brought upon a verified complaint of any person against someone who unlawfully holds or exercises any public office, and additionally limits that relief to a person who is bringing it. If they're bringing it in their own name, they have to be bringing that quo warranto action on the strength of their own title. Not only does the statutes require it, but the cases have reaffirmed that position over.
What exactly does that mean to you?
It means that we have to, Mr. Hamadeh would have to establish that he has right to the office, which he has not done. Because in order to get to the quo warranto relief, in order to be able to bring that claim in the first place, he would have to get the relief that's only provided for in Arizona law under the election contest statute.
Right, but isn't that, I mean, I follow your logic and I find it somewhat compelling, but isn't it a little bit circular?
No, I don't think it is, Your Honor. And the reason it's not is because, as we said, quo warranto is extraordinary. It's limited by the legislature for appropriate reasons.
But I mean, his argument is you counted, Maricopa County counted, I don't remember if you said hundreds of thousands, but a lot of votes that it shouldn't have counted. And I lost by 248. Is that right?
80.
Sorry,
Yes.
I'm asking her. 280 votes. And therefore, those hundred of thousands likely change the difference. So I have a right to that office. So why isn't, I mean, I'm not saying it's a winning argument, but why is that just a frivolous argument?
Because it is using the remedies available under the election contest statutes, which are only available if you bring it within the 5 days.
Yeah. But we have a separate statute that allows quo warranto.
Right, and under Jennings versus Woods, you have to read you have to harmonize those statutes. And they can do that by giving power to the quo warranto statute, which says only the person who is entitled to the office can bring this challenge.
But how would anyone ever have the right to the title?
So, for example, in Jennings versus Wood, it was the holdover. So news broke after the election occurred that the corporation commissioner
So it only works if you're an incumbent.
Not only, well, there's another way. Theoretically, Treasurer Yee, because she is in the
Line of succession.
Thank you.
You signaled it very well by doing that.
I was just like blanking. And she was in the line of succession. So she could theoretically also bring that suit. Who cannot bring this suit is the losing candidate. The case law is very clear on that the losing candidate does not have title, and that the only way he can claim the strength of his own title is by throwing out the votes of everyone in this room who voted in 2022. And that is extraordinary.
But looking at the procedure, just the vehicles that we're using here, quo warranto and an election challenge.
Yes.
Does the quo warranto statute or common law say this is or this is not an election challenge? Are they mutually?
They are mutually exclusive. So the Donahue case is very, very clear on that point. It's a similar situation where a lady was denied an early ballot. It was 2 months, and it was brought only, and that's another thing is adding to the context of this. 2 months after the election, she wrote to the AG trying to get the AG to bring a quo warranto action. The AG refused, so she did. And then what the court said was, in order for a mandamus to lie, the petitioner must satisfy not only the substantive conditions for compelling a quo warranto action articulated in the opinion cited above, but also the additional common law prerequisites for the issuance of that writ.
Did the court sanction that woman?
I don't know, and I don't know if it was asked for, but this case is from 1978.
I'm just asking if they sanctioned him for making the argument.
Right, and so I'm trying to. I hope I'm trying to get to.
You just don't know, is what you're saying.
I don't know, but since that case was decided in 1978, we have Jennings in 1999. We have the two previously filed election contests, which raised the same argument. Although I know that Mr. Hamadeh and the plaintiffs, the appellants, try to distinguish the case in those prior cases by saying, well, that challenged the application of, that said the EPM wasn't right, And we're saying something different. We're saying that the
And they are
Maricopa,
saying something a little different. I mean, the end result is the same, but they're definitely using different arguments and different phrasing of those arguments.
they're using different arguments. But
How is the sanctions, I mean, give me your best pitch for sanctions is just not controlled by Rector, and we've got to throw those out.
Under Republican Party, what's your best
Right.
argument for sanctions?
My best argument for sanctions here is that this is absolutely, it's a very, very clear, hold on.
I mean,
Is it a long shot?
No, I don't think it's a long shot at all. I think that we have 100 years of cases that say you have to bring a pre-election, a procedure contest before the election happens. And not only did they wait, okay, let's assume that they're.
why don't you, the question I posed to your colleague, isn't this the statute of limitations? They tried to make an argument about discovery rule, and we don't usually sanction plaintiffs
Right.
for good faith attempts to get around statutes of limitation.
And I think that that's incorrect for a few reasons. First of all, if you look at the additional facts, as Mr. Spencer pointed out, that Mr. Hamadeh brought 2 additional lawsuits before this that raise the same claims. I understand that the way they're phrasing the claim is slightly different. However, if that was permissible, then we would be erasing preclusion altogether.
No, not preclusion. We could find that the case is precluded, but not that their arguments don't rise to the level of sanctions. So that's focus on that, please.
Okay. So Richard.
I mean, we don't, relying on claim preclusion, I've handled cases where we found claims precluded and they're not sanctioned afterwards for trying to get around claim preclusion.
Right. But what plaintiffs are doing here is essentially a never-ending nesting doll, because if they can just change from, okay, we think that the EPM doesn't apply the statute right, and now they're saying, okay, well, we can bring that same claim, but we're saying that the 2022 election plan doesn't apply the EPM right. And then theoretically, they could go and say, well, these Maricopa County workers didn't comply with the Maricopa County election plan correctly, and these workers, this group of workers,
at some point it becomes
right.
sanctionable.
And I think that if you have raised the same gist 3 times, other courts have said that the election was valid, not just your own. When you've gotten notice from Rule 11 letters, repeated Rule 11 letters from a number of different parties, when the key discovery, if you're basing it on
the fact that a defense attorney says this claim is frivolous and we're going to seek sanctions under Rule 11, that's proof.
No, absolutely. Any of these things in and of itself is. I'm not saying they would be. I'm saying you take them all together, and you just can't get without erasing 12349, which AZGOP versus Richard absolutely did not do. You can't. Those words mean something. And
so even if I don't think it's a winner, but I do find that his argument that there's at least a sliver of ambiguity in the 2022 phrase that should have, but might not have put them on notice that they were going to be looking at non-in-person early ballot records. That makes it frivolous and subject to sanctions.
I think that combined with all of the other elements, including the fact that this is the 3rd lawsuit in which Mr. Hamadeh has raised these same claims, slightly different words, same claims.
But if a plaintiff has got a gripe, we'll call it a gripe, and he loses one way and says, well, maybe the reason I lost is because I didn't frame my question right, and he raises it another way, and then that court rules and he goes, okay, now I've read both of these, and I say, oh, what I really need to do is challenge the pre-election procedures because I didn't have notice. Do we really want to sanction that type of behavior?
When when you're talking about the third lawsuit about the same thing, when it's very, very, very clear, because we have so much case law that says you need to be bringing these cases before the election happens.
But didn't your colleague say it was arguable but not correct, Judge Perkins' argument, that it is debatable that a signature verification that takes place after voting even constitutes I understand it's not a winner, but we're talking sanctions here, constitutes a procedure leading up to an election. Is that arguable but incorrect?
I don't think it's arguable, and I don't think it's arguable for a few reasons. First of all, it takes place, signature verification under Arizona law starts the minute early voting starts. Secondly, even the plaintiff's own argument that, well, identification is required for voter registration.
As to that first point, are you saying voting is not part of the election?
No, it absolutely is. But,
so that's not pre-election at that point, correct?
Well, it's taking place before election day happens, so it's taking place throughout this period. But because
the period that is the election.
Okay. Yes.
Okay.
But since, again, I liked Mr. Spencer's metaphor or way of describing it, that when those procedures are outlined prior to the election, and those are actually the procedures that are being followed by appellant's own argument, then that has to be challenged beforehand, or else we are getting.
I want to give you a chance to respond to his final question. I think you said 3 points.
I don't have any.
Okay. All right. Then we're out of time.
Thank you.
Thank you very much, counsel.
Yes, Your Honor. I just want to respond to a few points here raised. First is that the first two cases for Mr. Hamadeh were basically duplicative of what we filed here. That's just simply not the case. Looking at the pleadings from those cases, you can see very clearly, anyone can see, those cases were challenges to the lawfulness of the EPM provisions themselves. They were properly dismissed.
2019.
Correct, and they were properly dismissed as post-election procedural challenges. This case, in comparison, was a challenge to the application of the policy, which is the same issue actually in Lake.
2022.
Correct, and that's the same reason that the Lake case was actually remanded to the trial court for a second provision. As Judge Perkins observed, there are differences between instances of wrongdoing that are ahead of the election that provide the public with notice, and instances of wrongdoing that straddle the election that are hidden from the public because the actual process by which reviewers were doing something wasn't disclosed publicly. There's not a single public document, again, anywhere that explains before May of 2023 that signature reviewers would just have 2 images and need to scroll. That is very important for this court to understand. Secondly, I want to respond to the point that the 2020 signature verification guide has been adopted as law. That's simply incorrect. If you look at ARS section 16-550.1F, it explains the legislature intends that the illustrations of the broad and local characteristics of the 2020 Secretary of State Signature Verification Guide to be used as a reference. It goes on to explain that that ARS section, this is subsection G4, signature verification means the process of manually comparing the signature on a voter's affidavit envelope or ballot affidavit with the voter's signature in the voter's registration record. Again, using that term, saying it must be a document that is consistent with 16550A. And then finally, subsection H indicates that the legislature intends by this section to codify procedures based on the 2020 Secretary of State Signature Verification Guide, provided that in the event of any conflict between the guide and this section controls. Again, it requires a registration record comparison. Next, I want to turn to the overall question in this case. So the question this court must ask itself is, what happens when an election official whether it's intentional, negligent, doesn't matter. What happens when misconduct is concealed until after the 5-day period ends to bring an election contest? There must be a remedy. The Arizona Constitution is the supreme law of the land. And ARS section 16673 is a statute of repose. It acts to extinguish rights that individuals have, and it simply cannot override the constitutional rights of voters.
Question, are you done?
You go ahead.
With that? Okay. So Rick, the Republican Party, says, don't get us wrong. sanctions are still in play in the election context. And then they cite us to Kench v. Jansen. Are you familiar with that case?
Yes, Your Honor.
Why is this case not Kench v. Jansen?
So the Kench case with Mr. Hamadeh, that case concerned
Which sanctions were fine, the Supreme Court said.
So what happened in that case in the Supreme Court is Ms. Wright incorrectly cited the record below and made a false representation by mistake. That's not what's happening here.
Okay.
Now, going back to the quo warranto situation, I do want to talk a bit about that because I think it's important for this court to understand. Jennings stated very specifically that the quo warranto provision of the Arizona statutes and the election contest statutes must be read in unison so that neither one is superfluous. And there is a long history in this state from the Supreme Court and from the courts of appeals saying specifically that there are two ways to bring a challenge to an election. In fact, State XRL Hess v. Boringer.
What is your client's title that he can rely on?
So he has a superior title to the office of Arizona Attorney General, and that's because...
You're going to have to help me on that because let's say I agree 100% with you that there was 100,000 votes that shouldn't have been counted. We don't know how those 100,000 votes would have gone. It might have left the Attorney General Mays with an even bigger margin victory. So how can he claim he has a superior title based on that?
That's right, Your Honor. And the reason for that is actually this court needs to void the results for him, for my client, as well as for AG Mays and for the propositions across the board.
But then he wouldn't have any title to it. So again, going back, quo warranto is very limited, kind of discrete little thing. So how can we get to a title for him to bring it?
This relates back to the cases of Miller v. Picacho.
I think it's creative that you came up with these arguments.
Thank you, Your Honor.
But help me understand.
Yeah, so this relates back to the cases of Picacho v. Miller v. Picacho, which is a Supreme Court case, as well as a case from this court, which is Reyes v. Cumming. And in those cases, when you had a non-technical statute violated, and a non-technical statute, because of the progressive nature of the Arizona Constitution, is any statute that advances a constitutional right intended to protect the voters of Arizona. And so these laws in particular, ARS 16550, ARS 16152, 16-166, all of these are non-technical laws because they provide security to the people of Arizona to know that their votes mean something, to know that when a statute is violated, we have the right to actually bring a claim based on the Constitution to vindicate that right. Now, when you have a non-technical law violated within a jurisdiction, the proper remedy under Miller and under Reyes is to void the results of all votes from that affected jurisdiction. Now, if you take, for example, Mr. Hamadeh's race, he lost by 280 votes. We're asking this court to void all of the results from Maricopa County for both Hamadeh and Mays and recanvass the results, and this is plainly asked for in the complaint, from throughout the remainder of Arizona. So we would only count the lawful votes from Cochise County, from Gila County, from Yavapai County, from everywhere else, but Maricopa County's votes must be set aside as a matter of law. And that's really what the point here is. And now finally, I want to go back to the State XRL Hess v. Boringer. That case, as well as Campbell v. Hunt, actually explicitly recognize that you can bring a challenge outside of the election contest statute by someone who has lost an election. That's exactly what happened in State XRL Hess v. Boringer. And that court recognized this was proper, but they threw it out on a procedural issue because he had amended his claim improperly to basically file it under today's version of ARS 12-2041, which is the public attorney general quo warranto action, when he should have not amended his complaint. If he hadn't done so, he probably would have won that case.
Mr. Heath, you're out of time.
Thank you.
I want to thank both counsel for your arguments today. We appreciate your hard work in the briefing on this case. It was well done on both sides. I think there's nothing else. So with that, we will issue a written decision in due course. I'm sorry.
Yeah, the case has been accelerated for disposition. Do you have an idea of when in particular?
I think the statute requires us to issue a decision within 3 business days. So
Okay.
we would probably try and comply with the statute.
Thank you.
I think that's it. So we will issue a written decision in due course, and with that, we are adjourned.